Supporters of gay rights celebrated across the country after two Supreme Court decisions on same-sex marriage. Justices struck down the Defense of Marriage Act, which denied federal benefits like health insurance to legally married gay couples. The court also rejected California's Proposition 8, a ban on gay marriage. The state of Texas, one of 38 states that does not recognize same-sex marriage. So what do the court rulings mean here in Texas? Good morning to Lynne Rambo, law professor at Texas Wesleyan University School of Law. So is the court telling every state that it must legalize gay marriage? No, it certainly hasn't said that yet, Tim. The extent of the ruling yesterday was limited, and it basically found that the federal government, that Congress violated the Equal Protection Clause when it disabled same-sex couples who were validly married in states recognizing same-sex marriage from being treated as married under federal law. So it didn't reach that question that a lot of people were hoping and expecting that it might reach, which is whether or not states have to offer marriage on an equal basis between opposite-sex and same-sex couples. Now, the California decision was kind of a strange one as well, because the court did not weigh in on the merits of Proposition 8, but basically said the people who brought this case to the court had no right to bring this case to the court. So what are we doing here? Essentially, actually, they found that the people who brought the case were all right, but the people defending Proposition 8, as of the point they lost any official status, no longer were proper people to defend it. So yes, the district court, the lower court ruling got left in place by the Supreme Court. The Defense of Marriage Act, in particular, going back to it was a federal law, interestingly enough, signed into law by President Bill Clinton, and it singled out people, and that was what the court found offensive, was that it singled out one class of people and said, you will be treated differently from other people. That's exactly right, and that's what the Equal Protection Clause generally aims at, is when a majority seeks out a group and disables them in some way or discriminates against them for no public good other than the preference of the majority. And that's what the court found that Congress did by essentially preempting the ability of same-sex couples to enjoy the benefits of marriage in those states that had recognized it. Is there any hint in the rulings that the court is aware of or sensitive to changing public opinion, which seems to be changing more in favor of same-sex marriage, or more in favor of let people do what they want to do with their lives? You know, that is a great question. I'm not so sure that the tone of the majority opinion in Windsor sounds a little bit like that, but the circumstances of this really suggest that. And Justice Ginsburg in particular has been traveling across the country talking about the interaction between the political process and the judiciary, and specifically Roe versus Wade, and what would have happened had the court stepped back and allowed that to just take place. I had the distinct sense that one of the things the court is doing is trying to adopt a wait-and-see attitude as much as possible to see if the political process takes care of the issue as a judicial matter. Lynne Rambo from Texas Wesleyan University School of Law. Thanks so much. Appreciate your insight. Thanks, Tim.